The Panhandle may not be nationally known for much, other than spring break on the Redneck Riviera, but if you've ever needed to depend on the Sixth Amendment for the state to provide you an attorney, then you can thank the landmark Supreme Court case, Gideon versus Wainwright. Clarence Earl Gideon was born in 1910 in Hannibal, Missouri, and he lived a mostly transient life. He left home at age 14 and spent his life working odd jobs and also in and out of jail in Missouri, Kansas, and Texas. He was married 4 different times. By the time he and his 4th wife had moved to Panama City, Florida, he had 3 kids and was working as an electrician. The problems surrounding the famous court case all started on June 3, 1961. The Bay Harbor Pool Room was once located on Everett Avenue in Panama City, sort of between the areas of today's Millville and Springfield. The bar had been broken into in the early morning hours, cash taken from the register, and a record player and cigarette machine smashed. A local witness claimed to have seen Gideon leaving the pool room with a Coke, an empty wine bottle, and about $5 in change in his pocket. Gideon was promptly arrested for the break-in and for the theft. Now, Gideon could not afford a lawyer, and in his court appearance in Bay County, the judge told him that the court could not provide him counsel, saying this: "Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense." Gideon responded to the judge by saying, "The United States Supreme Court says I am entitled to be represented by counsel." Well, the court declined, and Gideon was subsequently forced to represent himself. The jury returned a guilty verdict, and he was sentenced to 5 years in the Florida State Prison down in Rayford. Gideon filed for a writ of habeas corpus with the Supreme Court of Florida, based on the notion that his Sixth Amendment right to counsel was violated. The court denied his request. While serving time at Rayford, he utilized the prison library and schooled himself in the law just enough to be able to file an appeal with the United States Supreme Court against H.G. Cochran, who was then the Secretary of the Florida Department of Corrections. However, in the meantime, Cochran retired and was replaced as Secretary by Louis Wainwright, who was then named in the suit. Gideon's argument was that his Sixth Amendment right to counsel had been denied in the original Bay County court case, as well as his 14th Amendment right to due process under the law. The Sixth Amendment reads like this: "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." Now that final clause there, that's what formed the basis for Gideon's case. The U.S. Supreme Court appointed prominent D.C. lawyer and future U.S. Supreme Court Justice Abe Fortas to be Gideon's counsel in the case. Abe Fortas argued brilliantly before the court, and on March 18, 1963, the United States Supreme Court returned a unanimous decision in favor of Gideon. In the opinion, the court cited 2 former cases that had led to Gideon's original predicament. In the 1932 case of Powell v. Alabama, the Supreme Court ruled that the right to be represented by counsel was fundamental to a fair trial in some cases, but whether this applied to capital or non-capital cases was hotly debated after the ruling. And in the 1942 case of Betts v. Brady, the Supreme Court had decided that unless extenuating circumstances existed, like illiteracy or other complications, then a court-appointed attorney in state courts was not necessary. However, with the ruling in Gideon v. Wainwright, the confusion surrounding the Powell v. Alabama ruling was cleared up, and Betts v. Brady was completely overturned. Clarence Gideon's original charge of breaking and entering with intent to commit petty larceny was not a capital offense, so the original circuit court judge in Bay County, according to Florida law at the time, could not appoint him a lawyer. But the U.S. Supreme Court, led by Chief Justice Earl Warren, now clarified that the Sixth Amendment makes no distinction between capital and non-capital offenses when it states that all citizens are entitled to counsel. The court also clarified that the 14th Amendment gave the federal government power to overrule state laws that denied Sixth Amendment rights to any citizen. The decision led to around 2,000 people being freed in the state of Florida, but it didn't immediately result in Gideon himself being let out of jail. Instead, he was granted a new trial, this time with a government-funded, court-appointed lawyer to argue his case. At that trial on August 5, 1963, just 5 months after the Supreme Court ruling, Gideon's lawyer was able to discredit the earlier testimony of the sole eyewitness in the original trial, which led the jury to quickly return a verdict of not guilty, setting Gideon free. Gideon later died of cancer in 1972, and his family had him buried in Missouri. The Bay Harbor pool room eventually burned down, and today a parking lot is on the site of this former bar and pool hall. The results of the case led to increased protection of the rights of accused citizens, expanded the power of the 14th Amendment, and led to the appointment of a state-funded attorney, becoming something we now consider a foregone conclusion in all criminal cases. And this landmark ruling happened right here in the Florida Panhandle.